Court of Appeals, Division 1 is now in session.
Thank you all. Please be seated. Good morning. This is the time set for oral argument in Anthony and Victoria Garcia versus Alfonso Saavedra, forgive me, and others. Our case number CV140153. Each side is allocated 20 minutes for oral argument. Appellant may reserve a portion of that for rebuttal. If you wish to do so, you'll need to keep track of your time at the clock on the podium. Out of respect for counsel, I would ask those in the court in attendance in the court make sure your phone's off. I don't want counsel to be interrupted as they're making their presentations. We have read your briefs. We're familiar with the record. We've conferenced the case this morning. We would ask you to keep that in mind as you present oral argument. Our proceedings are being recorded and will in due course be posted not only to the website but also YouTube. So as you begin your argument, please tell us your name and the party that you represent. Before we get started, are we doing okay on the clock for respondent? It's showing up here at zeros, and I just want, as long as it's showing 20 on both sides, I'm getting thumbs up. So as long as counsel are in good shape, we're in good shape here. So with that, Mr. Friedman or Mr. Rasmussen, who's presenting today? Mr. Friedman. Very well. Please proceed.
Good morning, Your Honor. And Your Honors, may it please the court and opposing counsel, we're actually fine if they get zero amount of time. I'm here on behalf of my clients, the Garcias and CR Ramirez, who are also in the court, along with Mr. Rasmussen. It's important from our perspective that our clients actually get to see the process, which obviously involves a very intimate part of their lives. And it's also important for all of us because we're so involved with the law to understand that these cases are not just based on theory, they're based on real people and real situations. And this is one of those real situations. As you can tell from the briefing, Anthony Garcia and CR Ramirez were essentially victims that were stopped in traffic when a bus literally rolled over the back of their vehicle and came perilously close to completely running them over as well, and they sustained some pretty serious injuries. In the case, it comes out that throughout the course, after discovery ends, the sudden incapacitation defense is brought up. The court allows it. I'm not going to delve into those issues in great detail. That is an abuse of discretion, and the court can determine, this court can determine whether the judge abused his discretion in that manner or not. What I'd really like to focus on, if it's okay with the court, is the jury instruction that was provided to the jury in this case. Imagine that there's a driver driving a bus, and the driver leaves from Flagstaff. And that driver feels great. It's a normal day. It's sunny outside. Birds are chirping. A little snow on the ground. Driving through Munns Park, this driver starts to feel a feeling of an aura, of a headache coming on. The driver thinks, well, I'm not sure what's going on, continues on driving. The headache gets worse and worse and worse as the driver continues on. He gets to the turnoff for Prescott, and now his vision or her vision is enclosing. And he or she is still able to steer the bus. The bus continues going south on I-17. And the driver thinks, maybe I tapped something, I can't remember, but continues on driving. Continues on driving, gets down to New River. There's some traffic up ahead in New River, and the driver continues straight on. And because of the migraine that's been going on for over an hour, plows right through traffic. According to the jury instruction that the judge in this case gave, and by the way, we have nothing against Judge Oberbilling, and I've known him for a number of years, the jury would be left with the thought that That is sudden incapacitation. And that is because of two flaws within the jury instruction that was given in the case. The first is that the driver has to know before they leave their home, even if they're driving for hours at a time. The second is that there was no instruction on loss of control. In that case, the driver kept relative control of their bus, as in our case, where the driver kept relative control of his bus. In fact, the facts are undisputed that the driver from the first minor sideswipe accident drove 1,739 feet in a straight line before he hits the vehicles in front of him. After that point, where 12 vehicles are involved, he drives an additional 1,900 feet. He drives almost 3/4 of a mile. Now, he says a number of different things, and the court's aware. First, my brakes don't work. Then he says, well, my foot got caught in the pedal. And he's adamant that he does not faint, that there is no fainting spell at all. That's what he tells the police at the time, and that's what happens in the trial transcript. We know that he continues straight in a line. He's accelerating. He's braking. He's swerving around a raised median. He's swerving back over a raised median. He comes to a controlled stop 3,700 feet or 3,600 feet from where everything begins. In this case, as in the Word case, the jury could come to a conclusion that there is a sudden incapacity defense regardless of whether he could control his vehicle or not. And why can they come to that conclusion? Because they're never instructed on the issue of controlling his vehicle.
But counsel, didn't you, I don't know if you presented closing argument or.
I did.
Okay. Didn't you specifically tell the jury exactly, precisely what you just outlined for the last 3 or 4 minutes? You told the jury these things about control and what the sudden incapacitation defense means, and that means that it's not just an intermittent event, it's not a partial event, it's something that's a complete losing control of the vehicle. I mean, the words control, I don't know how many times were used, not a whole lot, I'm not going to say, but I believe both you and opposing counsel both informed the jury of that. So isn't that a fair factor? I mean, isn't that an important factor for us to consider in determining reversible error?
Judge Brown, I think that point is right on, because I think that I maybe a little bit less eloquently stated that to the jury at the time, but the jury doesn't have to listen to my argument. An argument is an argument, and they're instructed before that argument that this is an argument by counsel. What the jury is looking to is the judge in the case.
But the Supreme Court has told us numerous times in determining reversible error, we look to the totality of the record, including, and they've specifically pointed out, and our court has specifically pointed out, we look to the arguments of counsel in determining whether the jury was misled, whether they weren't properly informed.
And I think that the Word case is right on point in this. I mean, it has a very factually complementary scenario to this, and that's the North Carolina case, where it says that the jury, in fact, is misled if they're not instructed about the issue of control. That was not done in this case. The judge is the one who's telling the jury, these are the factors that must be conveyed. One of those factors is a complete loss of control. So we can argue, and the closing argument is just that, but it doesn't have the same conveyance to a jury as a judge telling them so.
And I understand that position. What I don't know, given that I don't pretend to be an expert in North Carolina law, is whether they have a body of law like we are asked to apply from our Supreme Court about what happens if a jury instruction perhaps isn't technically quite what it should be. And I think the Supreme Court in Arizona at least tells us, well, you can look to what what counsel argues, not only to see if it was implicated in a party's position, and you see that sometimes in criminal cases, but also whether counsel's argument, not that it was evidence, but that it accurately reflected what the law is in determining prejudice. And so I understand what you're saying about the word case, but I don't know that that body of law is identical to the body of law we, by definition, are asked to apply.
Understood. And I think what is instructive to this court is look at the closing argument of the appellees in this case, the counsel for Mr. Saavedra. They did a fantastic job in this case. And they argued that, well, this guy, he didn't control it well. But it's still that's still sudden incapacity.
Wasn't he quoting one of the witnesses?
Yes.
On that?
Yes. Okay. And he's telling them, but that's sudden incapacity.
How's that misleading?
It is because the issue is a loss of control. That is the issue in this
saying
case.
It's a complete loss of control?
It's a complete loss of control.
But counsel, but that wasn't in your instruction. That wasn't even in the two-part instruction you submitted, was it? That there was a complete loss of control? That sudden incapacitation requires a complete loss of control?
I think one has to look at the term of both loss of control and incapacitation. There can be, I think the defendant in this case argued partial incapacitation. The law in Arizona is not partial incapacitation. It's sudden incapacitation. That means total incapacitation. The law in this case is loss of control. That doesn't mean partial loss of control. That means total loss of control. The Arizona Supreme Court and Court of Appeals in the two Arizona cases talk about those issues.
It seems like you're suggesting that you have to be slumped over the wheel, passed out, like unconscious.
Well, I think that the two Arizona cases...
Completely unconscious.
And that's why I think that this is a good issue for the Court of Appeals, because I think Arizona needs clarification. As you know, the two Arizona cases, that's exactly what happened. They were both dead.
Well, they were both dead at some point.
But
nobody knows exactly when they died.
The Court of Appeals determined and the Supreme Court determined that they were dead before they died. And the juries in both of those cases determined that they were dead before those accidents occurred. Both of those cases still continue to talk about control.
One case seems far-fetched. Both the driver and his wife were dead at the scene. How could anybody...
Well, and if you read into that case, it explains the reasoning that the jury had in that case, and the reasoning that the experts had is that the driver, and that was the judge that ended up being deceased, that he had very inconsequential bleeding as a result of the car accident itself, while his wife had bled all over the place because she was still alive at the time. That's how they came to that. I can't address whether that's true or not.
In both those cases, they're quite a far distance from what we have here.
Judge Wren, I couldn't agree with you more. I think that's why Arizona needs clarification as to, and I think it's instructive, we have two sudden incapacity cases. Both of those individuals are dead. They have a complete loss of control. They are totally incapacitated. We wouldn't be here if that was the case with Mr. Saavedra. Mr. Saavedra instead was able to control his vehicle. And he continued to control his vehicle. And he continued for 3/4 of a mile going around a median and coming to a controlled stop.
Why isn't the degree of loss of control just a classic jury question? Factual? Are you suggesting that a judge on a motion for a directed verdict or on summary judgment is going to have to make this determination? Oh, there's just not enough there for this defense, that seems like an awfully close call. Let's just say, I don't know if this is a medical far-fetched or not, but if you're driving along and then you have your legs go numb. Okay, I don't know if that's a phenomenon that could actually occur, but they actually go numb. You're able to steer the vehicle, but you cannot literally move your legs in order to brake and stop from colliding with something. Would you be able to receive a sudden incapacity instruction in that? Would that be justified?
And I would tell you that it depends on the facts of that case. Most likely not, because there's many things that the driver can do. They can turn the vehicle. They can avoid harm's way to other drivers. There's a number of things that they can do in that situation. In this situation, he continues on. Think about what sudden incapacity is. It's a total defense. It bars a claim. It is the ultimate death sentence to a victim that has no comparative fault in a case. If the court is to liberally interpret the provisions of control and incapacitation, the court is giving license to individuals who get into rear end accidents and come up with, oh, I fainted right before that. And that's not somewhere that I think that the state of Arizona wants to go. Incapacitation is incapacitation. Loss of control is total loss of control. This is a complete bar to a valid, viable claim of victims. And the court should strictly interpret the words used and the defense used of sudden incapacity. And I'd like to reserve the remaining time.
Thank you, Counsel. Mr. Conlon.
Justices, good morning. I'm Scott Conlon, and I'm here representing the appellees, who in this case are defendant, now appellee Alfonso Saavedra, first student, and I believe the school district was still left in this. And if it please the court, I'd like to proceed, and I'd like to proceed specifically to what Judge Brown mentioned regarding the language that was used in the closing arguments. I actually pulled it out thinking that we might get here, and this is exactly what the appellant said there, and it's from what the transcript, which was placed in and put in evidence, and it's at page 40, line 9 to page 41, line 4. Sudden incapacity is not a headache. It's not dizziness. It's not lightheadedness. It's not inattention. It's not looking in the mirror at the children. It's not looking over your right-hand shoulder talking to one of the students. It's not pressing the accelerator instead of the brake. It's not getting your foot caught in between the pedals. Incapacity is not having problems being able to steer. It's not having problems being able to accelerate, not having problems with being able to brake. That's not incapacity. The jury instruction that you received says sudden incapacity. It doesn't say sudden altered consciousness. It doesn't say sudden partial incapacity. It doesn't say sudden relative incapacity. It says sudden incapacity. The lack of capacity, the heart attack driving, die, hitting people. And in the record, we objected at that point, to which Judge Oberbillig said overruled. It's argument, counsel. And that's exactly what it is. And that's exactly what the Supreme Court permits the parties to argue, to argue their version of what the instructions would say. And in fact, since there was a question about this, on the opening brief on page 19, there was a little blurb put in about the way that we, the appellees, represented this. Now, in the blurb given by the appellants, there is other language which is put in bold by them, and I'll read the whole thing, but I'm going to emphasize the point which is not emphasized, which I think really undermines a lot of the argument which the appellants try to bring. Plaintiffs want you to believe that incapacitated means unconscious. It doesn't mean unconscious. It means he wasn't able to control his vehicle. He was dazed and confused. He was incapacitated. He was not able to make good decisions relative to driving the bus. Now, appellants didn't object to that language at all, and in fact, it says, this is the appellee saying he was not able to control his vehicle, which comes back to the basic principle that we're heading for in terms of the instructions, which is essentially Judge Oberbillig got it right when he said, and this is again another quick blurb I want to go from our answering brief. I mean, what do you really need to have a word physically incapacitated defined? Because
well, let me ask you, because I understand what you're saying, and we've focused on that in some respects, but I think appellant's argument more bluntly is that lost control is not used anywhere. It is included in at least one of the two jury instructions that they proposed pretrial. That specific phrase, lost control, appears in the Goodrich case. And again, the incapacity issue we're dealing with here does not come up every day. But that language does not include The final jury instruction given does not include lost control.
Right, and we take the position, frankly, in agreement with Judge Oberbillig that it's not necessary. It is essentially subsumed within the phrase. It is subsumed within the phrase physically incapacitating event. The issue here turns out to be, and again, going back to what Morris says and what counsel also said, the facts of the case dictate large part where we go. In this case, the claim was instruction was given, as was requested by the appellants, for a loss of control and a lane change instruction, I believe. It was the negligence per se Raji instruction. And that, of course, talks about control. Then we come to the instruction saying sudden incapacity. Well, incapacity means capacity. Capacity to do what? Well, the only issue in the case is the ability to control the vehicle. That's all that's there, and it's subsumed. We contend that it's subsumed within the phrase. It is common sense.
Would it have been inconsistent with the two Arizona cases we have, the published cases, if instead the Superior Court had included the lost control concept? Would it have been error to do that?
Would it have been error to add it?
Yes.
No. What I think it would have been is probably what we've submitted. It would be unnecessary enhancement. Obviously,
but your own instruction, your client's own instruction had control language. You didn't say lost control, but you said the district in the second paragraph. The district is not negligent if Mr. Saavedra, while driving the school bus, was suddenly stricken by a physical event which he could not reasonably foresee, which rendered him unable to control the school bus.
That's true.
I'm assuming that there's nothing, not only was there nothing wrong with that language, it's probably your clients thought that was the law. Or, I mean, that was part of, why would you include that instruction?
Simply because we wanted to be as complete as possible. That doesn't mean that that doesn't mean it's incomplete if it's not in there. And I think that's the point. For instance, Goodrich, for example, it didn't address whether you needed control or not in the language. It reviewed a language which the trial court offered and didn't comment either way on it.
I didn't comment, I know. So, but why did Judge Oberbillig not go with your instruction?
Well,
I mean, why?
His statement is I'll give you exactly the way he explained it at the motion for new trial, and I believe that's also quoted in our answering brief. And at the time that this was being argued, it's at page 34 and 35 of our answering brief. The court, I mean, do you really need to have a word physically incapacitated defined? Because that's where you're kind of going here. To me, those two words together are self-defining. I mean, use your common sense. The jurors, and at that point, appellant's counsel, while trying to continue their argument, basically acknowledged that. So the position where I understand Judge Oberbillig was coming from was you don't really need it. If we're talking about physically incapacitated in the context of the evidence and the facts of this case, it really is self-explanatory. It's a common sense issue. And in this case, over and above that, it just so happens that both appellees and appellant's counsel were able to argue freely whatever they thought was their appropriate way of telling the jury what they felt was the issue and how they should find on it.
But let me ask you, we get to, I think, and help me understand your argument, we only get to what counsel argued in closing if there is some genuine question about whether the instruction was correct. Would you agree with that?
If I don't remember that particularly off the top of my head, but if that's a true statement of law, obviously I won't disagree with it.
Well, and I wanted to make sure I understood your position, because it seems to me that looking at counsel's argument in this context with the question of a jury verdict or a jury instruction, you don't go there unless there's some real pause about whether the instruction was accurate to begin with. We don't have to look to these sort of secondary sources, if you will.
Right.
But please continue.
Well, and presuming that to be correct, our position is that there was nothing wrong with it to begin with. The only two jury instructions that Arizona has gone off on are ones where, for example, in Morris, the only issue was whether someone was dead. So there wasn't dead before or after. So there wasn't even an issue of someone, a witness saying whether something had happened to someone beforehand. The person was dead. There was no witness to what happened to Judge Bond, and it was simply a question of was he dead before or after. The instructions didn't need to go any further than that. And as Morris says, the facts are going to determine that, and I think that is part of the peril in trying to add definitions to things. When you start trying to over-define things, then I think you may come close to creating a problem. I don't know if it would rise to the level of a comment on the evidence, but that's always an issue to be concerned about.
Is it a definition problem, or is it an element? Because I mean, if you look at some of the other jurisdictions, including the Word case from North Carolina, it says there are 4 elements, and one of those is lack of control, loss of control, lack of control of the vehicle, as an actual element. And then the court went ahead and actually remanded that case because it said the jury had not decided. They couldn't tell that the jury had actually decided one of the key elements of the defense, which is control. So, I mean, to say, I'm not sure that it's such a definitional problem or what are the elements of the, I think that is it a threshold matter? What are the elements of this defense? It hasn't been around, twice now in 50 years, but in reported decisions, what are the elements, and were those elements accurately reflected in this case? I think that's the question.
Well, Arizona, I'm not sure that the Morris or the Goodrich have actually stated the elements. I mean, what Morris talks about was a specific issue, whether someone was dead. What Goodrich talks about is it goes to what it considers the critical element was if there was an incapacitating event, and I do recognize that there was a control reference in Goodrich. The issue which it went to, in the Goodrich court went into, was the particular issue of whether whatever happened to the individual, whatever incapacity occurred to them, was something which would have been foreseeable to them, and that's the focus that the Goodrich court went into. So the elements, at least as Arizona holds it so far, is that you have an incapacitating event. There's 2 jury instructions out there. Neither one was specifically adopted by the other, but what you have in the more current 30 years ago, I guess, jury instruction is that the issue of sudden incapacity goes to, okay, do you establish the fact that someone was incapacitated? Then the question is, was there any foreseeable reason to believe that the individual could become incapacitated when they got behind the wheel? And it's the elements. I can't speak in part to the North Carolina issue because 1, they've set their own, and 2, I don't know what the other instructions were. To be able to say to be able to say what sort of negligent issue they were dealing with, whether it was any discussion of loss of control, what their other instructions are regarding negligence in the first place. I also don't know, as you've discussed, what their standards are as to what they're looking at. So without having a full picture, I think it's potentially misleading to rely upon Word for that purpose.
Well, what about the fact, let's talk about control here, and I don't know if I'm slipping into sufficiency of the evidence here, and you can point that out to me if I am. But to what extent did the bus driver here can maintain control when he's able to travel, approximately over 3,000 feet?
Well,
during this episode, I mean, when did the lack of control start, and when did it end?
Well, I believe. I'm going to double check on this. There is a quote which I believe we had in our answering brief from from appellant's expert Patrick Hannon, which I believe talks about this. I don't know if it answers the fullness of your question, but let me see how far it goes. Let's see. It's on page 17. And did you test? This is Patrick Hannon, who is appellant's expert. And did you testify, did you not, that the impact between the bus and the Comtrans van happened very quickly, perhaps in 250 milliseconds, which would be roughly a quarter of a second? Answer, yes, sir. Question, that you believe Mr. Saavedra was impaired before he entered the curb lane is also reflected in the fact that he did not stop when the sideswipe accident took place. True. Answer, yes. In other words, post-impact with the Comtrans van, the fact that he kept going, kept moving, some, in this case, 1,027 feet. I think this means before the impact with the first pickup truck, before the big accident, would indicate to me that his mental state was impaired. So under appellee's own experts, Mr. Saavedra was impaired almost immediately just before or just after the time of the impact with the Comtrans van. And that's also consistent with what plaintiffs appellants, accident reconstructionist expert Mike Broughton said. This is also cited in our answering brief, and we did this in part to try to summarize a lot of what was testified to at the time, which is, let me see if I can find this. Okay, I want to make very sure. Okay, it's true. This is from answering brief, page 17. It's true, isn't it, sir, that the students on the bus almost universally said that after the first impact, his, meaning Saavedra's, head was either falling forward or his head was back, but he wasn't responding to things which were being said to him by the kids. Isn't that right? Answer, yes. Question, you read those interviews taken by police following the impact. Is that right, sir? Answer, that's correct. The evidence, there was significant evidence put all through the trial by both the plaintiff's experts. I didn't even get into the defense experts, although there's probably a reference in the brief somewhere. And actually, even if you go into various portions of the transcript, I believe it's page 5 and 6 of the opening brief by the appellants, they try to introduce certain evidence by Saavedra as a statement of that he had some level of control, but also interspersed in that is language of I lost it. Things didn't make sense. I was dizzy, and I'm paraphrasing there because I don't see it immediately here. But there was a lot that was significant evidence all through the case, which started from the moment of the police report that there was impairment, and there was impairment from the moment of either just before or right at the time of the first impact, a half a mile away from where this accident finally stops.
Does impairment equal incapacity?
It probably depends upon what the action relative to it is, what the facts are. And what the facts are in this case, which is important.
But doesn't that cry out for, like, wow, it should have been a definition. It should have been fleshed out better here. What? Well, for the jury.
If you define then how much is too much and how much is not enough, and at what point are you taking away an issue for the jury to decide? I guess that's a real issue.
And that's fair, but sudden incapacity, almost by definition, has to be a fairly high standard. It's something more than headaches or dizziness or, impairment in a lay sense, okay? Because otherwise it would tend to negate an enormous amount of things, and it hasn't. At least that's not been Arizona's experience. But when you talk about incapacity, sort of the headaches, that seems quite different than loss of control. And that's what we're asked to struggle with. So I understand that was trial testimony that came in about capacity, but that seems sort of different than loss of control.
Well, the loss of control, whatever different people, and different people did opine on what exactly hit Mr. Saavedra. Saavedra had his testimony. The witnesses, the students, the experts through the students all had their testimony, but there was one constant which all the experts, I think, agreed to, and it's shown and indicated in the facts as indicated in the opening brief and in the response brief. You take whatever happened with this person, then all the conduct that happened afterwards. 20 plus seconds after the first collision with the van, the vehicle's accelerating. It's missing the turn it's supposed to take. It hits a Dodge pickup in front of it 1, 2, 3 times while still accelerating. Continues, hits 13 other vehicles at 52 to 53 miles an hour, 10 over the time of the accident, veers into an oncoming lane. What all the experts said is all the individual had to do, anyone in their right mind would have to do after that first impact is hit the brakes, stop the bus. The factual enormity of it pointed, along with the testimony of what was going on with Mr. Saavedra, to the conclusion which I believe the jury reached, which was something was wrong, and it was sufficiently wrong that he was incapacitated.
And perhaps, so it was a general verdict, right? Is that?
Yes.
But would you agree of this now being the third case that, to our knowledge, sudden incapacity has sort of bubbled up in the appellate courts? This is the least sort of extreme. The other two cases, people were dead. I mean, the incapacity resulted in, or perhaps came after, they passed away. Not that somebody something wasn't firing quite right. And particularly in that case, doesn't that sort of put the spotlight on the loss of control?
It would only put the spotlight on the loss of control if the loss of control is an element that has to be placed in it by definition. And I've seen nothing that indicates that by definition it has to be there. I understand what the word case says, but I don't know what else is there. What we have to go on are the facts of this case and the four corners of the jury instructions given, which include discussion of, here's general liability, and liability in this case would be incurred by the Rajis, loss of control. To which the instruction which comes right after it says, look, if the person is physically incapacitated, then there's no liability. I mean, you don't even go to that instruction if you don't find control in the beginning, because there's no need to. So the instructions read as a whole cover sufficiently whatever needs to be covered in this case. And I don't believe the instruction standing by itself, I think, is sufficient, and I think it's also sufficient given the circumstances that within the four corners of all the jury instructions, the jury was clearly was given a clear picture of what they had to decide.
Counsel, can you tell us how much time you have left?
I've got 7 seconds.
Okay. All right. If you wish to summarize in a sentence or two, we'll get that.
We've talked about. I'll try to talk about the instructions. We've talked significantly about the instructions, so I won't add much upon that.
I truly mean a sentence or two.
Yeah. The only thing I would left to say, it looks like it's been left to the jury on this issue of raising it. I think that issue begins and ends with, if nothing else, the initial disclosure state of the appellees. I don't believe I think it's an issue that was undermined by them from the beginning. I have nothing further to add than I think the discussion we've already had.
Thank you, Mr. Collins. Mr. Friedman, rebuttal.
I'm going to keep this very brief, which I know everybody says when they come up here, but nobody ever does. The issue of a total loss of control that we discussed during my opening statement, it is addressed in both cases in Arizona. The Pacific Employers Insurance case talks about that a situation wherein the driver is rendered incapable of control. That is a total loss of control. That is on page 12 of the Pacific case, which is then cited by Goodrich for that proposition. That is the law in Arizona. That instruction should have been given to the jury. Had that instruction been given to the jury, defendant wouldn't have been arguing, or the appellee wouldn't have been arguing to the jury that he was not able to make good decisions relative to driving the bus, because that would have been out. If there was a complete loss of control or a loss of control, making good decisions does not amount to a complete bar of recovery for victims. That's all that I have.
Thank you. Thank you. Counsel, thank you all for your briefs and for your oral presentation today. We appreciate them all. We will take the matter under advisement. We'll issue a ruling and written ruling in due course. Thank you. We stand adjourned.